Good afternoon. The topic, as you're aware, is the move forward. We did last time object and purpose, and we now move to subsequent agreements and subsequent practice in relation to interpretation of the law. Let us see what the law that we have in place. The reference that we have in a codified form at the international level is the Vienna Convention on the Law of Treaties. Article 31, paragraph 3 refers to that alongside the text, context, there shall be taken into account any subsequent agreement and any subsequent practice and any relevant rule of international law established between the parties. Let us try and understand the intention behind having such a formulation. The first point that obviously emerges is that the text, which is the subject matter of interpretation, has not been considered as the only source of intention of the parties to the text. In other words, in order to understand the contentious text, reliance certainly has been placed specifically on the text, but that reliance has not been considered to be the only source of deciphering the intent of parties. Therefore, the Vienna Convention says that any agreement subsequent to the text, which is the subject matter of the convention, will be relevant in interpreting the text. Number two, any subsequent practice between the parties will also be relevant for the purposes of interpreting the text. And thirdly, it also says that any relevant rule of international law established in relations to the states. So there are three elements post the conclusion of the treaty. Please try and understand. We have a text that is contentious, on which parties rely for their contentious claims. That is the text. Then we studied context. Then we saw object and purpose. We revert back to context. In other words, context we saw is both limited to the text, which is both intra-text and is also inter-text. So the context is not merely to be found from the text of the treaty, which is the subject matter of interpretation, but which is also to be found from outside the text. And we saw it most notably from the example of the shrimp turtles case. We also know it, although we did not discuss in the class for paucity of time. The beef hormones case, where Law of the Sea Convention was relied on. We also saw it from the same beef hormones case, WTDS 26 and 48, if you want to write the reference, where the Rio principles were referred to. So the point there is context also allows the interpreter to go outside of the text. So it is not merely for the first time we have in subsequent agreement, subsequent practice, or any relevant rule of international law that the interpreter is allowed to move outside of the text. Context does also allow, as we have seen, the interpreter from going outside of the text. The conclusion from this preliminary point that arises necessarily is that the source of the intent of the party to a treaty is not necessarily confined to the text. It goes beyond the text. We call it, in one sense, in one way, context. In another way, we call it subsequent agreement, subsequent practice, and any relevant rule of international law. This is the position at the international level. This is the law of interpretation which is codified in the Vienna Convention on the Law of Treaties in Article 31. We do not have a parallel or any supplementary text on the international level which refers to any relevant rule for the purposes of interpretation of any international agreement. Let us see the position at the domestic level. I again recall your attention to the fact that we have seen that on the domestic plane, given the types of legal systems that we have in the world, common law legal system coming from the United Kingdom, being followed substantially in the United States, Australia, India, Pakistan, Malaysia, Sri Lanka, Bangladesh, these countries. You have that civil law system originating from Italy, more popularized by France, being followed in Germany, Austria, Bulgaria, Romania. In United States also, in one of the states, Louisiana for instance, or in Canada, in one of the states, Quebec. Then you have Islamic legal system, then you have Chinese legal system, then you have Hebrew legal system. So you have a number of legal systems. There is no common element that we find in all these legal systems comparable to a source that we have on the international plane in the form of the Vienna Convention that we can look to for the purposes of interpretation. That is a point that I have been making consistently in my presentations. Specifically to this point, if we should find out, is there anything which is parallel to subsequent agreement, subsequent practice, or any relevant rule of international law, maybe not international law, then whatever, domestic law, but that is subsequent and outside of the text, then we find a couple of things that you should note. First of all, amendment is a process which is very well known to both common law legal systems and civil law systems. It is not, in other words, it is not uncommon to have a written law and to have amendments. If I should give you an example of India, we have a written constitution in this country since 1950, and we also have since 1950 a number of amendments. So for instance, if there is a particular provision, let us see if Article 21 of the Constitution is the subject matter of interpretation in relation to education and right to life. Obviously, Supreme Court of India is going to also rely on 86th Amendment, or for that matter any other provision of the Constitution may not be interpreted in disregard to or in isolation from any other subsequent amendment to that particular section. So on the domestic plane, one source which is subsequent to the text is in the form of amendment. And there can hardly be any controversy about it. When I say there can hardly be any controversy, I have specifically in mind the competence to make law at the domestic level. It is coming from the same legislative body which has made the law. So, the law-making body is basically making amendments. Now, there may be questions for an extended analysis, for instance, such as any administrative practices in the absence of a law, whether they should be binding on the Supreme Court of any country in deference to the written constitution. The answer always is no. Insofar as amendments in the form of ordinance are concerned, there is absolutely no doubt between a legislation in the form of an amendment and an ordinance, because an ordinance is basically a legislative act. Ordinance is not an executive act, because an ordinance is promulgated only if it is not possible to have an act of parliament. And it is not surprising then that ordinance ceases to have effect after a certain period of time once the legislature meets after the promulgation of ordinance. So there is no doubt about its legislative power. So this is about one source of subsequent intent is amendment, whether in the form of legislation or in the form of ordinance. Amendment means addition, deletion, clarification. It includes all. So amendment is a neutral term. It doesn't mean, it means, you can say, if a loose term is to be applied to amendment, you can say change. Amendment is a change. It may be very comprehensive. Yes, please. Yes, what happened?
Sir, I had a question.
Yes, please do ask.
You were saying that amendment is a source of intent, but I feel amendment is a source of law. There is no need to have intent in that, because once the amendment is brought, that becomes ultimately the main law. So we need not to search the intent. Now, if you say that we should search intent into that, then I have another question. As we have seen in 2006 or 5, there was in section 6 of Hindu Succession Act, it was brought that female will have the equal right in the share of the father's property. Now there is a concept of pious obligation, but pious obligation is given only to the boys, not to the girls. So if we search intent to bring equality into that law, then we find that when it comes to the girls for pious obligation, they are excused from that. So if we search intent of equality into that, then we will have to search for both, that equality in pious obligation as well as equality in the father's property. So we are not having here that equality. So how do we find that amendment is a source of intent?
Yes, amendment is a source of intent because amendment is to a parent law, to some law, as for instance the law that you have mentioned and the amendment you are mentioning. For instance, I told you, you see the other amendments to other law. So just as a provision, just as any article in the Constitution, whether it is 19 or 14 or 21, is the source of the intent of the legislature in the form of the words which are used in that provision. Similarly, an amendment to that particular section of the article is also a source. Whether changing, whether that change is in the form of deletion, whether the change is in the form of addition, whether the change is in the form of modification, conformed by the actual words used. So in other words, amendment is also a text. There are words in an amendment. There are words in a provision. Article 21 comprises of words. Amendment 86 also comprises of words. So what is the intent of 86 amendment is to be determined on the basis of the meaning of those words used in that provision. So therefore, both main provision, the parent legislation and the amendment are sources of intent as to the law which is expressed in those particular provisions. Because if we do not believe that it is not a source of intent, then the question will be, what do we do in a given case if there is an amendment and there is a relevant question that goes to the Supreme Court on right to education in relation to Article 21. So what do we do with Amendment 86? We have to at least, even if we say it is irrelevant, but we have to consider it. The court will consider it. Say that yes, we have seen it, but we don't find it to be any relevant in this particular case. You cannot simply disregard it. There is a difference. A determination as to irrelevance, if following consideration is a judicial determination. If it is without consideration, then there is a problem. Yes, I am not saying those situations where neither party has relied on those amendments. You are aware, in a contentious case, you have to make a specific claim. And if you have not made a specific claim, then I agree with you. Then it is not a source of intent. Then I agree. But that is basically, you have to, you see, when you are making a general statement in the sense that in a specific case, if you do not invoke, I can give you several examples where parties have not made a claim and the adjudicatory body had discussed those provisions, but ultimately after discussing it, adjudicatory bodies have found, then we make no observation on the basis of this, basically because parties have not made a claim. I should give you, because you are reading intellectual property, that reminds me of a case concerning patents which went to the WTO, WTDS 50 case. It is a ruling by the panel of 5th September 1997. In that case, panel, after having considered the claims made by India and United States, did not rule on transparency claim. Why? Because this was not included in their request for consultations. And once it is not included in the request for consultations, it would not be deemed to have included in the terms of reference of the panel. And once a provision has not been included in the terms of reference, the panel will not rule it. I should give an example in the Indian, or in other words, in domestic law. If you have not made a claim in your prayers, in your writ petition, the court is not going to give you what you believe should be given to you. The court is going to say you have not made a claim. It is only in the very rare cases the court would allow on your specific application to amend the pleadings, which is a very, very rare. So if you have forgotten something very important, okay, then obviously, whether it is an amendment or whether there is anything else, will not be a source of intent. But that is a very general case and a specific case to a particular litigation. But ordinarily, I think it is safe to say, we must say, it is also a source of intent. To the extent it is probative of the provision that it has been made on. Yes, please.
Sir, we had heard in domestic law there is intent of legislators or framers, those who frame the law, to find out what the law actually is. We go for the intention of the framers or legislators. But how does it differ, the intent of the framers or the legislators, from the intent of amendment?
You see, if you see, it is a very good question that you have asked. We can test it like this. Let us see Parliament is a body of people. Parliament is not a human being. Now, how do you find the intent of Parliament? Do you speak to one individual? You don't. How do you find intent? There is no other way to find the intent of Parliament on a given case than on a decision taken by Parliament. Then, once you go to the decision, whether it is a decision to make an amendment, a decision to pass a law, then you have to read the law. Once you read the law, then you have to give meaning to the words used. And it is on the basis of it, you will be able to say, then this was the intent of Parliament. So Parliament is a they, not it. And the intent of the legislators is a metaphoric, in the sense that they can only be attributed intent on the basis of a collective decision which was taken in the name of Parliament. It was not taken in the name of Mr. X, Y or Z. You may speak in Parliament when you present a vote. You see it, for instance, Judges Judicial Accountability Bill is being debated. You have Mr. Arun Jaitley had something to say. Mr. Kapil Sibal had something to say. Now you tell me, once it is passed in the law, then you please tell me, how do you know what Kapil Sibal said, what you say, Arun Jaitley said? There is no way. There is no way, because I am sure it will not be written. There won't be even a footnote to a bill. At the most, it is part of the parliamentary proceedings where their views have been recorded. If at all the court is of the view that such a bill, if this becomes a law, in a given case could not be interpreted without knowing the actual speeches made by the members of Parliament, then voting and debating, then it is a different question. So therefore, when we talk of the intention of Parliament, intention of the legislature, we do not speak of intent of those human beings which are comprised of Parliament. It is basically a collective act promulgated, passed, formalized in the form of a text, and on the basis of which we attribute intention. You will be very surprised. It's a very good question, but you will be very surprised to see. Please tell me, Honorable Pranab Mukherjee or earlier Pratibha Patil, whatever, these presidents, anybody else, they are also presidents for those political parties who did not vote for them. Can you say that he is not my president? I never voted. I had no intention to elect this president.
President for PS as well. But my question is, then what is the relevance of looking into the proceedings? Why, when there is problem, like whenever the Supreme Court has this problem, whether India is federation or not, why does it refer back to the Constituent Assembly debates? Because if we have to find out intentions from the text only, then the written law is very clear. The Constitution of India has written in black and white. There is no problem. But why do we go to the discussions taking place in the Constituent Assembly debates? If the individuals have no weight, then why do Supreme Court refer to that? It's like
again, a very good question. You see, the point is, why do we go to parliamentary debates? You must await at least one more class and we will discuss Pepper versus Hart case. That is the most celebrated case on parliamentary proceedings. I told you in the beginning, I don't know whether you were present in those classes, there is no uncontroversial clarity or ambiguity in the law than what is so stated by the body competent to say it. If the Supreme Court says it is not clear, it may be clear to you or it may be clear to me. It is immaterial. Our clarity is immaterial. Please gracefully accept it. So if it is clear, it is not clear to them, then they will go to every record they find is probative of unclarity. So the question is, it is a question of competence, and it is the competence of that adjudicatory body. We may discuss it as a scholar. Yes, there is a role for us. There is a difference. Our role is, we may read their decisions. We have seen it, the RTI decision where the court was saying that you must have some degrees. Were you present in that class where we discussed?
My question is totally different. My question is, you said that the individuals, what parliaments say is the text. It is not the individual which matters. It's the collective. You said just now. Whether what Kapil Sibal said or Arun Jaitley is immaterial, because nobody knows what he has said.
No, it is part of the proceedings. It is there.
Now consider it one step further. If Arun Jaitley and Kapil Sibal are member of the Constitutional Assembly debate at that time, let them be late. Now, what happens? Why Supreme Court looks into the matter? What the debates were on at that point of time? Now, Supreme Court why looks it? I do not doubt your saying that Supreme Court has doubt. It means everybody has doubt. I have no problem with that because that's the fact. Now the thing is, if everything is in text, then Supreme Court should deal only text. It should not go to the Constitutional Assembly debates. It goes to Constituent Assembly debates. It means that Supreme Court is taking weightage or reference from those debates, and debates are always by individuals. Like in that group, because Supreme Court often directs B.R. Ambedkar's view on federation. It says that it's illegally because it's the demand of the time. So, while saying that the Supreme Court says that India has a federation, it relies on particular individuals' debate. Now, my question is, as you said now, that individuals carry no weight, then how do we find the intent of those? Everything cannot be judged from the black and white text of the Constitution. So, we need to find the intent of the legislatures as well.
You see, there is a difference. What you are saying is this. The Supreme Court, whether it is the Supreme Court of our country or Supreme Court of any other country, interpreting a written constitution. The whole question is this, the source of intent. You start with words. When you say words are not capable, that is the point you are missing. That is the gap in your reasoning. The question is, we are not discussing intent, the source of intent in isolation from that determination. These preliminary things we often assume in a class which is of postgraduate and PhD students. The whole question is, you start with a text, and if the text is not dispositive of the question, then the question arises, where do you go? Then you have a list. It's not that you have only one parliamentary debates. You have several things. If you go to the practices of national courts, the list is very long. The law is not that clear and happy as it is on the international plane, because it is very subjective and very unreal. The realistic plane is basically Vienna Convention. You can compare it. Now, for instance, you have posed this question in domestic context. What the court will do? The court says, yes, the golden rule is read the text. If you have a problem, if you find absurdity, if you find repugnancy, then you go modify the text to conform it to the intent. It is a circular question. Again, the question is, in giving this solution, you are basically posing a question. Again, how do you, to what extent you will modify, and how do you know the source of modified intent? So, Supreme Court doesn't say. It will say, yes, you modify. You see, there is a difference. In stating what the rule is one thing. In applying that stated rule is another thing. So, application, principle and practice, there is a gap. We know everywhere, be it from the United States case of McLeod versus Maryland, Chief Justice Marshall. on the specific issue of parliamentary debates. Justice Learned Hand from the United States. Parliamentary debates, and for instance, why not sitting judge Justice Scalia, one of the best known you see on legal interpretation. There is a big debate which is enduring, the relevance of parliamentary debates. There are you see people saying that we should absolutely reject. There are those who say yes, why not? If you can decipher intent, you can even go to the parliamentary debates. My point is, if Scalia happens to be part of the majority saying that parliamentary debate should not have any value, believe me, that decision they will disregard it, throw it away. Next day he becomes a minority, the majority becomes majority, they will consider it. So the point is this, for us, we may debate it, discuss it, but what matters ultimately is the competence. If you see ultimately, the point that you are saying is basically, it's not, theoretically we have no problem. It is basically the practical issue. And the practical issue is inextricably tied to the issue of the competence of the organ interpreting.
Sir, should we infer intention from preamble of the Act or parliamentary proceeding or both? If your answer is parliamentary proceeding if at all, then I have a fear that it may be possible that self-serving advocacy groups, as it is happening in USA or in India also, their intention may become part of the parliamentary proceedings.
You see, the point is this. In the domestic plane, basically this is a debate which may take place in the context of domestic scenario. Domestic scenario is this. In this country, there is altogether different rules and different mechanism of interpretation which is not very sound, which are not very happy, which are too mechanical because there is so much a gap between theory and practice. But let us take it on the general domestic plane where there are less controversies. I told you, and I was repeating it, it is basically a choice of methods. If you are in doubt, you means the court. Again, you have to accept it. There have to be certain assumptions before you can talk. We can talk about this mic only if my definition of mic and your definition of mic is coincide. If you say that it is not a mic, then no matter how beautiful explanation that I may give of mic, you will never agree to it. The whole question is this: first, let us agree. If the court says that the text is not clear to us, the problem arises then, how? Where do you go to clarify it? What do you do?
Sir, as it happened in Nira Radia case, we are not living in paragon of virtue. We are aware of the fact that how political outlets and self-serving advocacy outlets are influencing the policy of government of India or government of the world at large. And so in the light of all those facts, I would like to say, sir, that they are actively investing a lot of energy in terms of money, in terms of article, in terms of literature. So don't you think that...
I have seen it a bit. I totally agree what you are saying is, but let me also tell you, this is not so easy for courts to say that the law, the text is not clear. They have to say something more than this.
Sir,
yes.
Last one. Suppose, sir, this is a building and there is always a ventilation space. So there is always fear, like good wind also come or harmful wind may also enter inside. In the same way, the legislature or parliament has is a structure and it has some ventilation or ventilator space. Through that space, it may come or it may influence the mind of the parliamentarians because they are acting on them. They have 2-3 persons. They are going to them. They are meeting to them, and they are giving bribes and everything. So in that way, even the parliamentary proceedings, if you give parliamentary proceeding the amount of a kind of legislative value, then it may be better for the judicial system.
I totally agree with you. You see, I told you, it has not been, at least we can agree on the empirical evidence, what has been the case. Let us wait for one more class I have already devised those readings. Pepper versus Hart we will discuss. That is the best known case in the common law world, at least on parliamentary proceedings. We will read this case. Try and understand. Once it is not clear to the court, it is then a question where to go. There are advocates, conservatives, saying that we should leave the matter then and there, because this is not our job to make law. We should defer to Parliament and say clarify to us. But there are others who would say, no, we have other methods and we can find out the intent of Parliament. So this is, please try and understand, we can't change it. This has been a perpetual debate. Academically, it has been very well attended to. The conclusion that comes is of twofold. Please try. Your views, both the views that you have expressed, are the views which are already there in the academic world. What do they say? To you, it will answer that this argument presupposes the immutable clarity of the text, which is inherently false. The argument that you takes that immutable clarity of parliamentary intent, which is again false. So therefore, the bridge is that sometimes the text is objectively not clear. And then the question is, where do you go? And if you go to parliamentary intent, it is not bad. Then it is your coming to you. The objectors would say that the parliamentary, if the text is not clear, you leave it. You leave it there. This is not your task. Ask the parliament to clarify it. But the problem is, what will happen to the litigant? The advocates, the theorists who talk about judicial process, most notably who talk about, who have written and care about justice, they will say, what will happen to these people? Will they wait? So these are we can't give so clear-cut answers because we don't want to mislead. You see, constructive vagueness is to be preferred for deceptive clarity, including in academic discussions. We do not want to be deceptively clear. Along this should be the case, this should not be the case. We can't dare do that. So this has been an enduring. If you want to read literature, the best known sitting judge you see there in the United States is Justice Antonin Scalia. You read him, he is the best. He's given so many judgments. We have a couple of judgments we have discussed in this series. For instance, Chevron case, we have discussed. You will find references there. You will find his position there. You will also find the case which modified Chevron, and then you can find his dissent. So you can see it. It's not that if you please read the literature and you can find out. Let us go, you see. But I'm happy that you have raised these queries. These are very fundamental questions. So you have on the internet, let me summarize the point. There is hardly any debate that these are definitely the sources of intent. How they are used in a given case, please do not get confused, has very little to do with academic understanding, but much to do with the adjudicatory body, its competence and its function. That is basically their domain. But it remains. Whether they use it, they don't use it, it depends on the circumstances given the statute. On the international plane, at least 3 such subsequent sources of intent have been stated expressly in the Vienna Convention. One is subsequent agreement, another is subsequent practice, and the third is any relevant rule of international law. We move forward. If you see the cases, you will find, and also academic writings, there is a general agreement, mind my word, general, that there is no clear cut, again note the word clear cut, these 2 adjectives are important, distinction between subsequent agreement and subsequent practice. This is the fundamental. I will not explain because time is less. I will wait for your queries. If you have, then I will respond. Now let us see, let us test a few of these. We have seen there was a convention, there was a General Assembly resolution of 1996, which the text refers to the year 17 January, but it was 17 December when it was adopted. Doesn't matter. A General Assembly resolution on terrorism. Now I ask you, what did you read this resolution? Did you find anything relevant to our discussion? What did you find, you see, in this resolution? Anyone who has read it? General Assembly resolution on measures to eliminate, combat terrorism. Any convention? Did you find any reference to any convention? I am saying any, because there are references to a number of conventions. And this is how, when you see this text, you will find it how difficult it is to actually understand these texts in the context. Now the text is General Assembly resolution. There is a reference also to the 1951 Refugees Convention, which is a convention. Then there is this 1996, 1951, 1996, hence subsequent, saying that the convention shall not be interpreted, applied to give refuge to the perpetrators of terrorist act. I leave it to you to read the details of the Refugees Convention. But it is a very significant, very significant statement. So to the extent that it expressly refers to, in 1996, to a convention of 1951, which had also had a protocol already agreed as early as 1967. It is a manifestation of either a subsequent agreement or certainly a practice. Because to the extent that it is a manifestation of a practice, there is a case very well known in the international literature, that is the Nicaragua case, and several other academic writings, not academic writings, certainly this case for the proposition that duly adopted General Assembly resolutions do amount to practice by states. So you have this, see, that sentence very subtly says it. It's very difficult to apply it in practice, given the wordings of the Refugees Convention, attended with the practice of uncontroversially defining terrorism. So this was, you see, one example. Another example, you see, was in the context of the case that I forwarded to you, the advisory opinion on Namibia. Anyone who had the chance of reading this case?
forwarded by Security Council to the International Court of Justice for advisory opinion under Article 96 of the United Nations Charter, in which the matter was that the question was that the control over Namibia by South Africa was justified or not, and Security Council posed the matter before the International Court of Justice whether it was legal or not that South African control over the Namibia. It was matter in the question.
Yes, very good. Anybody else who would like to add to these quite correct statement of facts? Essentially, this was the case. But if you could be little more specific, it would really help our discussion. What he said is absolutely true, no doubt about it. What I am asking is a little more specific. Please add specificity to this correct statement. You see, there was an advisory opinion, no doubt about it. There was Security Council resolution, there is no doubt about it. Whether South Africa's control or whatever these things were there. Let us see the specific aspect of it. The specific aspect of it was that the Security Council had adopted a resolution. Resolution number 284, asking South Africa to leave Namibia, that was southwest Africa. South Africa did not do it. Then the Security Council asked a question to the International Court of Justice, requesting it of an advisory opinion on the question of legal consequences for states, means other than South Africa, for South Africa's continued presence in the southwest Africa, that is Namibia, despite the fact that the Security Council had adopted a resolution asking it to vacate it. This was so this makes the point that he is making a little specific. It was in this context that this advisory opinion was given by the International Court of Justice. Now, now then, please get to the context in which we are studying this advisory opinion, because we are not studying these cases otherwise than for the purposes of our understanding. Did you find anything relevant for our discussion? I think we are discussing subsequent practice, subsequent agreement, and relevant rule of international law for the purposes of interpretation. That is the subject. We are not discussing it outside of this particular framework.
So South African contention was that Security Council doesn't follow the rules, and it held that it does not follow the due process.
Again, absolutely correct answer, but it will be a little more specific about it. It's absolutely correct, but it's too vague. It will be a little specific, and that specific aspect is very well known from this advisory opinion. You see, South Africa raised an objection to the ICJ giving advisory opinion, and this objection was so fundamental that court had no other option but to address it. And this objection was that according to South Africa, this resolution 284 was not adopted by a concurring vote of all the permanent members. Therefore, yes, true, that is true. Even otherwise in the voting, you see, the voting takes place in International Court of Justice as well. When you have contentious cases, you can see on the operative part, you have a voting. You can see In fact, the voting is so important that even in one single case, and it's a very good point that he has made, even in a one single decision, if there are 5 parts to a decision, 5 parts, you can see the voting patterns of judges are varying. On point 1, Judge A is saying yes. On point B, the judge is saying no. So if there are submissions, let us see 4 submissions have been made by the claimant, and you can see the votes are varying from the members. It is not that if a member is for or against, it depends on which proposition. On this point he says, well, I have no problem, but in this point I have a problem. And then it is more complex than merely yes or no. Sometimes there is a yes, but reasoning is different. So the judge is not filing a dissenting opinion, but filing a separate opinion. So the question is, the judge is concurring in a judgment without joining the opinion. So he said, well, I have no problem, you give it to him, this, but not for this reason, but for this reason. So he would record his reason. It is sometimes more nuanced than this. The judge is not even recording a separate opinion, but recording a declaration. How do you distinguish between a declaration and a separate opinion? Example, Nuclear Weapons Advisory Opinion of 8 July 1996. And the most fantastic thing in that particular case was that Justice Muhammad Bejovi, who was president of the court, as a judge voted in one way, and as the president of the court voted in another way. That is the most peculiar thing to know. So in 2004, I had some chance of interacting with one of the judges who was, party to this advisory opinion, Judge Guillaume from France. So I asked him this question. Of course, it was a private conversation. So I asked him, please tell me, what were the reasons for Justice Bejovi for voting negatively as a judge, as an individual judge? But when there was a tie, 7-7, then he voted against his own opinion. And Judge Guillaume had, he hesitated, and because it was, he said, well, because his first language is French. So what he gave, the answer what he gave was in English, the term that he uttered was saying, well, it was very understandable, his reasoning was very well structured, but I could not get a clear-cut answer from what he was saying. Because the stance was totally different. He had one thing to say as a judge, and another as the deciding judge, as a president. So how do you count his position? And what he did was, he appended a declaration saying that why he casted his vote, against the position that he took as a judge. So what do you say about a same human being taking 2 positions on the same issue and justifying it on the changing position? He is saying, well, there I had my own opinion as a judge, but when there was a tie amongst the judges, 7-7, so I had to decide. Why didn't he retain that position which he had expressed as a judge? Obviously, what is that? But the question is, again, these are some of the things. That is what I say. A good student, a good researcher must also give as much attention to practice as he or she gives to the theory. Look at this example. A judge voting one way in the same case for the same proposition. To be very crudely, he said, as a judge, for the illegality of nuclear weapons, and as president said, I don't know whether it is illegal or illegal. That is very surprising. The answer you see, some people have said that consistency is the virtue of fools. I express no opinion on that. I would, as a student of international law, respond like this. It is basically a question of competence. Two different positions taken by one individual on the same proposition in the same case cannot be answered without controversy unless in terms of the competence. He had two competences. One competence as a judge, he did it. Another competence as the presiding judge, he did it. You tell me, what is the legal correlation between the two? Law had conferred on him two positions. He had exercised both the positions. What is the problem? Was he obligated by the law that if you take one position as a judge, you are bound to take that position as a presiding judge? If it were so, then the question arises, why do you give two positions? Why don't you count that position? So in other words, the law that gives two competences ex ante presumes that there is a possibility that the same individual may change his position. So let us see. Please try and understand. These are sometimes a practice. Lawyers tend to presume that something which is logical, something in order to be correct must be logical. And that is the reason in the very first talk we referred to several writings by such as Oliver Wendell Holmes, Hart, which would testify to the fallacy of the limits of logical reasoning as to the correctness of a legal proposition. It is not necessarily always a logical thing to be legally correct. Mind my words always so that you don't misquote me. Let us move forward. Another case. This is a very famous case, Corfu Channel case. Again, a very famous case in the sense quite early. Did it come before the international court? Just please recall some very important facts only for the purposes of our discussion. Subsequent practice, agreement and relevant rules. Did you find anything, any statement, any conduct by the parties in this case? One person should not be expected to read every case, isn't it? You've read two cases, right? Any other person who has had any chance of referring to the Corfu Channel case? I'm sure you must have heard about this case. Tell us about it, whatever you know. You see, this was about state responsibility of both Albania and United Kingdom for the incident occurred in the Corfu state. Two ships of the United Kingdom Royal Navy were destroyed. Thereafter, the United Kingdom Royal Navy entered the territorial waters of Albania and swept mines in order to prevent any further occurrence without informing, let alone asking for permission of Albania to do so. Now, United Kingdom, having first seized of the court of its jurisdiction, and the international court in response to it, after having rejected the objections filed by Albania in the first round of proceedings, was seized in this case on merits, subsequently on the basis of a special agreement which was signed between the government of the United Kingdom and of Albania to submit to the International Court of Justice their dispute, especially as regards two specific aspects of state responsibility. Firstly, the amount of compensation which the United Kingdom had claimed of approximately above 8 lakh pounds, 1948-49, of the government of Albania, and in turn, government of Albania requesting the International Court of giving a judgment to the effect that the conduct of Royal Navy in entering its territorial waters without informing it was a violation of its sovereignty. So in other words, in the language of law, two claims were made. One was the claim to make compensation. The claim, this was on behalf of UK. And another was to give satisfaction. Satisfaction is a legal term in terms of remedy. Satisfaction is a legal remedy. So you would never have otherwise thought about it. Satisfaction is a legal remedy. Because if the court gives a satisfaction in favor of one party, it means that the other country was found to be in violation of some rule, norm of international law. Otherwise, remedy does not follow in the absence of the finding of a violation. Now, the issue before the court was whether the court was also asked to fix the amount of compensation. That was a very tricky issue. You see, that is what we say. If you submit a text to lawyers, or the sanctity of a text cannot be said to have unimpeachably survived unless it has survived the scrutiny of at least an ordinary lawyer. And in this case, there were no ordinary lawyers. Some of the best known lawyers were there, at least for the United Kingdom. The issue was whether the claim of United Kingdom against Albania to give compensation also authorized the court to fix the amount of compensation. It was basically, the dispute was not about, the contentious noun was not compensation, the contentious noun was amount of compensation. That was the issue on which we have included this case. Now the court's reasoning was, the court said yes, it does include that. The reasoning was, firstly, there were two submissions. First was to give compensation, and second was to give satisfaction. Now, if parties had agreed that the court was authorized to pronounce as to both, the court which was authorized in either way was also authorized to give due compensation. So the word due in abstract, due is an adjective qualifying the noun compensation. So how do you know concretely that something is due without specifying it? How do you translate an abstract proposition of due into a concrete expression of due in a given case? And please try and understand, the pleadings of the United Kingdom are incorporated in the judgment which talks about, if I correctly remember, more than 8 lakh pounds, which is stated there. 7,50,000 pounds for the loss of ship, and 75,000 pounds for some other destroyer damage, and 50,000 for the personnel's inconvenience, whatever. So 8,40,000, something like that, whatever amount it was there. Now, so International Court of Justice in this case attributed to both the government of Albania and of United Kingdom a subsequent practice in coming to the court. They came to the court after the court had rejected the objections of Albania. That is number one. Second, in this coming to the court and signing a special agreement, a compromise, specifically agreeing to compensation, the court attributed to both these countries that it could not have been their intention, and they had come to the court for compensation without authorizing the court to fix the amount of compensation. What compensation would you give? You won't again fight over it. Suppose the court says you give compensation to him. The next question is, how much? You say 8 lakhs pounds. You say it is only, I will give you only 80 pounds. So what do you do? It is a nonsense. A court which is authorized to say that compensation should be given is obviously authorized to fix the amount. What is the great thing about it? Nothing. So the court said there is absolutely no doubt about it, and the subsequent practice of both the parties is absolutely clear that they have authorized the court to also fix the amount of compensation. So what you can see is the main point that emerges is from a statement. See, look at the difficulty of discerning the practice. That is one thing that you know, because if you read the text, the law is so coached, you see, in the language, sometimes it is very difficult to decide whether this is part of the English language or it is a statement of law. So the cruciality of language in the statement of law is no less than the cruciality of language in the statement of any other social science. So when you are reading a text, a legal text written in English is no English, it is law. For it were otherwise, a text written in Arabic would become a literature on Arabic. So this is the lesson that you get. Look at it, how subtly you read those 2 pages and then see it's not easy to discern subsequent practice from such a cutter. It is not that the parties have said it, these are my subsequent practice, so you can read it. You have to read them. You can see the earlier conduct, then you see their submissions, then you see the actual formulations of the compromise, and then you should be able to come to this. So the point is this: the first statement that we made in the beginning, that there is no clear-cut distinction between a subsequent agreement and a practice. And here we must conclude that there is no simple or ex ante way of determining the subsequent practice. Secondly, there may not necessarily be only one text on the basis of which one practice may be determined as a subsequent practice. In this particular case, at least there is a reference to 2 texts. The text where Albania made objections, which was gone, prior proceedings. The second was the text which was relevant in this case, which had conferred jurisdiction on the court on the basis of a compromise that these countries had signed. So at least you could see in this particular case 2 two texts were found to be determinative of the practice that the court found to be was subsequent, and on that basis the court came to the conclusion that since the party had authorized it to give compensation, due compensation, therefore the court was necessarily authorized to also fix the amount of compensation. This was about this case. The third text that I give forward to you was, let me give a context. Subsequent agreement and subsequent practice in the interpretation of treaties is currently a subject matter of study of the International Law Commission. Please try and understand. This is currently being studied by the International Law Commission. This year, in May, International Law Commission had provisionally adopted certain conclusions about subsequent practice and subsequent agreement in the matters of interpretation of treaties. Now it's only 1 or 2 pages, 2 pages text, maybe not more than 2 pages. The main point that comes out is that the International Law Commission is saying at this stage, please note that this is provisionally adopted, which means it has not been finally adopted. Number 2. Second, the International Law Commission has not concluded its study, but yes, there is no doubt about it. Even a provisionally adopted text by the International Law Commission comes after a considerable study, and I did not give you that text where you can find evidence of considerable study, because that will be too much to give. But certainly, since there is a reference, you can certainly read Professor Nolte's report on subsequent practice. You will find hundreds of illustrations. The ILC is saying that subsequent agreement and subsequent practice are authentic means of interpretation. This much at least you can know. There is a specific statement by the ILC. These are authentic means of interpretation. So notwithstanding the difficulties of discerning, notwithstanding the almost, you say, consensually agreed absence of distinction between the two, it goes without saying that it is part of the Vienna Convention and it is an authentic means of interpretation in the interpretation of international agreements. Let us see the behavior, because Vienna Convention itself is a product of International Law Commission. So it is not that anybody else, the rule where you find the statement about these two factors. It is also included in an agreement which was formulated by the International Law Commission. And the same commission is further studying this particular, because the international practice is very diluted. Because on this point, let me tell you, I had a great difficulty in giving you, you see, in shortlisting the text. Believe me, at least there are 10-15 cases which I can cite you right now, where the practice is diametrically opposite. I gave you some very solid and where there is very little controversy about it. And that is precisely the reason why International Law Commission is studying. Because even otherwise, a subject matter which is before the International Law Commission, there must have been some very sound basis. There is something to study. Otherwise, ILC would not be studying it. So that is about it. After having seen so much of divergence in the practices of different tribunals as to the relevance, as to the value, interpretive value of these, the Commission is already of the view that these are authentic means of interpretation. Any question on this point? Then we move to a third element, because we discuss both these jointly. Subsequent agreement, subsequent practice, consistently with the understanding of these two provisions in academic writings and also in judicial decisions. Now we come to, you see, we take up the relevant rule, the importance of relevant rule of international law in the interpretation of treaties, and for that we have two references. One is two references from two absolutely different, you see, types of tribunals. One is International Center for Settlement of Investment Disputes, ICSID Tribunal on Economic Law, is based on a treaty that was Washington Treaty 1965. Another is the very famous case, MV Saga 2 case, that is from the Law of the Seas Tribunal, Hamburg, based on 1982, Law of the Sea Convention. So let us see both these and see how they apply the relevant rule of international. Let us take up the exit case first. This is of exit case of 1980 case. Here, one SAARC country was also involved, Sri Lanka. Anybody from Sri Lanka? There were 2 students. One student was from Sri Lanka, used to attend. I saw one day. You have no student from Sri Lanka?
We have students.
Okay. So there is you are certainly not prevented, you see, from discussing a case. Very quickly.
So again, the compensation was in the question that Sri Lanka entered into the bilateral investment agreement with the Hong Kong, and there was a company, Asian Agriculture Private Limited Company, and it had a business. It has invested in Sri Lanka, and it had a agricultural farm and carried out the business of shrimp. And due to Sri Lanka in 1987, there was a Tamil insurgency in the Sri Lanka, and that farm suffered a huge loss and destruction due to the counter-insurgency by Sri Lankan forces. And Article 8 of the treaty was in the question that that firm demanded the dispute was handed over to the International Center for Dispute Settlement that was held in Washington and at Washington Tribunal, and it marked that $8 million was in the question as a mark of compensation that it must, under Article 8 of the bilateral investment treaty, that was in the question, that they must settle their dispute by means of arbitration, and again the amount of compensation was not fixed, and the question was that what amount of compensation should be given or not.
Absolutely correct. So I congratulate you for making so close a reading of the case, which is by any standards is not a simple reading. To cull out the relevant facts from a text, very difficult, because there are so many facts, every sentence is so many facts, it's very difficult at the end of the day to remember the relevant. So you have done a commendable job, you see, in reading it. Let me summarize. There was a bilateral investment treaty between Sri Lanka and United Kingdom to invest in Sri Lanka in the form of shrimp culture, which means shrimp farming.
So it was Hong Kong,
A subsidiary of that UK company. Asian, you see, this was Asian Agricultural Products Limited. This was the company. Through its subsidiary incorporated in Hong Kong, Serendip company, that is immaterial. The point was, there was a bilateral investment treaty. Had it not been investment, ICSID would not have been the tribunal. Please try, and this is how you should be able to know the relevant. There was an investment. The form of investment was shrimp agriculture. So who was investing? United Kingdom or Hong Kong? Whether it was United Kingdom or Hong Kong, it was not Sri Lanka. That is relevant. Investing where? In Sri Lanka, which was not in dispute. The form of investment was agriculture. In agriculture, it was shrimp farm. There. So this investment was made by United Kingdom or Hong Kong in Sri Lanka. In 1987, as he correctly stated, this so-called investment got destroyed. This is a statement of the claimant, ASCL. Again it is a statement claimed by ASCL by Sri Lankan army. So, in every case, whether it is a domestic case or international case, you must be able to attribute a fact to the other party. Then only it becomes opposable to it. So the claimant was saying in this case that Sri Lanka, because it was Sri Lankan army, Sri Lanka destroyed investment and we invested it. Look at how positions are becoming contentious. We invested it, Sri Lanka destroyed. Therefore, we are asking for money. So you give us compensation. This was the issue. Then we go to, these are the facts, we go to law. As I said, there was a bilateral investment treaty. There were two provisions which were relevant in this case. Article 2, paragraph 2 and Article 8. One refers to jurisdiction which is not in dispute. Article 2 and 2.2 was in dispute as to its interpretation, and that is why we included this. Look at the positions of parties. Serendip or ASCL or United Kingdom or Hong Kong, other than Sri Lanka, the other party argued that Sri Lanka's responsibility is strict. I am sure law students may rely on their tort law analogy of Reliance versus Fletcher sort of. Strict liability. So strict has a different meaning in interpretation law, strict has a different meaning in tort law, or law of liability for that matter. Strict means that you are liable, there is no exception. Let us put it like this, just to simplify the point. Then Sri Lanka is responsible. The point Sri Lanka, why it was used strict? Because Sri Lanka was saying this was not destroyed by Sri Lankan army. There is a difference. There is a difference. That a policeman kills you or a bullet used by policeman killed you. The difference is, if it was intended to kill you, you were hit by it point blank. That is one way of killing it. The another is, then there were riots in Delhi and police was responding and somehow you happened to be there and it is a fact that you were killed by a bullet used by policemen. So the mere fact that what the bullet that killed you was used by policemen is not enough. Simply by making a postmortem report and finding the bullet, you can't say that police killed you and you are responsible. It was basically that case. So it was in this particular context that the significance of any relevant rule of international law came in. In the interpretation of Article 2.2 of the Bilateral Investment Treaty. It's a very good case for law researchers to see how international tribunals, or I must say lesser known international tribunals, ad hoc tribunals such as this, because ICJ is not an ad hoc tribunal, are interpreting the provisions of treaties and the approach they are adopting. Now, this tribunal, which had included a future ICJ judge, Mr. Al-Kosheri, he was president of the ICJ, of this particular tribunal. It delineated its own approach to interpretation. A, B, C, D. In Rule D of the tribunal's approach to interpretation, the tribunal specifically referred to Article 31(3), which we are discussing, relevant practice agreement and relevant rule of international law, which it found to be applicable. So that was its first, it stated its theoretical position, and that is the typical practice of civil law adjudication. Civil law approach, and that is where you can see the common law. In common law text, you won't find it's totally hodgepodge. But civil law approach is statement of facts, then relevant law, and then it would come to its decision. So it clarified that it would also consider Vienna Convention, and within Vienna Convention, it will also follow the relevant rule of international law. And then it came to interpreting paragraph 2.2. And what it deduced from paragraph 2.2 was the absence of unintentional reference to any relevant rule of international. What it said was, then parties may not be presumed to have intended to exclude reference to any relevant rule of international law. Because attribution of responsibility, a wrongful conduct, must be on facts attributable to the party whose responsibility is sought to be fixed. I told you, and I need not explain, the mere fact that the bullet that killed you was used by security forces is not enough to determine the liability of the security forces. I am not saying some responsibility will certainly be fixed, but what is the extent of responsibility? You are aware the difference between culpable homicide and murder. What is the difference? Bullet is there in both murder and culpable homicide.
Degree of it.
But the question is, there are other factors which, notwithstanding the same bullet, it converts into culpable homicide. So therefore, in this particular case, the act of destruction, the so-called destruction of investment of UK firm or by UK in an armed conflict, in a counter-insurgency operation, could not be attributed squarely to civil armed forces, and there could not be any strict liability. There is no such strict liability rule in the attribution without a strict attribution of the conduct which has been found to be wrongful. So this is how you see international. This is how the exit tribunal proceeded in its interpretation of Article 2.2. I repeat it. What is the crux? The crux is the court. The tribunal in this particular case did not specify what that relevant rule of international law was. At least I couldn't find it. But what is absolutely clear was its statement as to unintentional omission of any relevant rule of international. It is a very significant statement. If you draft a treaty, do you also draft in every provision all the rules of interpretation? Have you seen any such treaty or any contract, any provision, anywhere? If that is the case, then there will be a problem. Then other party will say, you have not included in every word all the rules of interpretation. If you include in every section, the claim will be you have not included in every sentence. If you include it in every sentence, then there will be a claim you have not included in every word. That is an absurd proposition. The question is, again, the question of competence. If you confer jurisdiction to exit tribunal, Article 8 of the treaty, tribunal knows the law. There are certain fundamental presumptions of adjudication. And one of the most fundamental presumption of adjudication is that it is for parties to prove facts, and it is for the tribunal to apply the law. Conversely speaking, parties must know their facts and prove them. It is your obligation. Because tribunal knows the law. if you do not accept this much, then you contradict yourself. Why have you agreed that the tribunal will have jurisdiction? If you don't accept that they know the law, they may incorrectly know the law. But this is the fundamental presumption. You have signed and tribunal will have jurisdiction. And tomorrow you say that you don't know the law. I have not written any relevant rule in Article 2.2. You have not written it. That is correct. But have you not conferred jurisdiction to me to read Article 2.2? So in other words, the answer, you see, the absence of the relevant rule in point 2, paragraph 2 is inconsequential. What is consequential is an undisputed and indisputable reference to exit tribunal wide Article 8. And that is basically the competence. This is a fundamental. If you do not accept it, and that is your own conduct, the same treaty, you may not have included relevant rule in Article 2.2, but you have signed Article 8, conferring jurisdiction to exit. And there was absolutely no dispute about it. And there was a dispute. One party was saying that you have destroyed it. Another party is saying, no, I have not destroyed it. This is an exaggerated statement. It's false. So when parties' positions are contentious, opposed to each other, there is a dispute, and there was jurisdiction to the exit tribunal, and it had decided. So this is an answer. Let us again come back and fine-tune our conclusion. The conclusion is the reference to a relevant rule of international law for the purposes of interpretation of a treaty is not to be expected to be present in the every provision of the treaty which is the subject matter of interpretation. It is enough that there is a reference to a body which is competent to interpret. If the competence is unfettered, the absence to every applicable rule of interpretation law of a treaty in every provision of the treaty is inconsequential. That is the conclusion that emerges from the agricultural, this Sri Lankan case. This is a very important point. Slightly different is the situation in the MV Sega case. Very quickly, if you know the facts. More specifically, if you want to read in the AASEL, if I should forget, read Rule D and paragraph 52. Very quickly to MV Sega case. This is from a different tribunal, from the Law of the Sea Tribunal. Very quickly, anybody who has the chance of reading this case. Alright. You see, here was a case between two countries, Guinea and, you see, this is Caribbean country, another, you see, country. And in this particular case, Grenadines, a ship belonging to Guinea was arrested. This was a ship, MV Sega was a ship of Guinea, a country, an African country, and here was a Caribbean country, St. Vincent and the Grenadines in Caribbean. It was arrested by this country. The issue of relevant rule occurred in this context. The tribunal found the use of force, as we understand it to be under general international law, and is considered inconsistent with the law of the Sea Convention, including Article 293 of the law of the Sea Convention. The question was whether the general rule as to the impermissibility, prohibition of the use of force in international relations and its exceptions were applicable to this case or not. Again, some similarities with Asian products. Article 293 does not state rules of prohibition of use of force, much less its exceptions. But the court in this case concluded that the force to be used reasonably and if unavoidably, then with necessity, are to be inferred from Article 293 of the Law of the Sea Convention. So you can see, it would be too late in the day if there should be a convention like Law of the Sea Convention, concluded as late as 1982, and prohibition of the use of force inconsistently, with the purposes of the United Nations or even otherwise, peaceful settlement of disputes from 1928, Rand-Collot Pact, and then United Nations Charter purposes, and then you have Article 51. Then you have Nicaragua case in 1986. Is it possible for two UN members to say that they are not aware of prohibition of use of force? And if you are aware of the prohibition of use of force, then you are not aware of its exceptions and how exceptions have to be exercised. So the question again, there is a lot of similarity. In neither case, in this case there is an express provision. That is why it is different. This point of distinction and points of similarity. Point of similarity are in the absence or in both of express statement of the relevant rule. That is the point of similarity. But the point of distinction was, in one case, the relevant rule was not expressly stated, which was found to be relevant by the tribunal. In the case of the Law of the Sea and the Sega case, the relevant rule was expressly stated, and that was the prohibition of the use of force. Or use of force as an exception must be reasonable, one, and two, with necessity. So even if it is unavoidable, you must use it reasonably. And the court did not use the term called proportionately, but this is a term which is very well accepted and used by several tribunals, most notably by the International Court. The word proportionate, the principle of necessity and the principle of proportionality in relation to use of force. And that is why you see this case is also very important. Here the court had expressly stated the rule, and despite its express absence in Article 293, found it to be present without expression in Article 293 and was relevant for the purposes of the interpretation of Article 293. So that is how you see this case was important. But anyways, I don't have to speak anything more, and I look forward to your questions. You're most welcome to respond and questions, comments, and whatever. Thank you. No questions I could do, right? Okay. Thank you.